Let's call this video Offshore Banking, how the wealthy stay untouchable even after losing in court. Picture this, you're standing in court, the jury just walked back in, the foreman clears his throat, guilty, liable, pay $8.4 million. The judge bangs his gavel, cameras flash, and for a moment your stomach drops. But that night, while your opponent's lawyers are celebrating, you're on a plane to Maui, because the assets they thought they'd seize are in a legal vault 10,000 miles away. So today I'm pulling back the curtain on how the ultra wealthy stay untouchable even after they lose in court. You'll see how the judgment creditors chase shadows, why certain countries slam the door on U.S. court orders, and what real structures keep money protected when the game's supposedly over. I'm Kevin, the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. And for 34 years, I've been protecting high net worth clients from lawsuits. And for nearly 30 of those, I've been setting up Cook Islands Trusts. In fact, my firm has established more of them than any firm on earth. And do me a favor, please, check and see if you're subscribed right now. And if not, please do so now, and let's build your fortress. Now, losing in court isn't the end, it's the beginning of the grab. Most people think the gavel ends the fight. Wrong. That's when the hunt begins. The second a judgment hits, lawyers launch post-judgment discovery, bank subpoenas, wage garnishments, asset search firms combing databases, even social media scraping. They call it enforcement. I call it financial strip search. If your assets sit in Chase or Fidelity, one court order freezes them. A simple PDF faxed to your bank and you're locked out of your own account. Statistic, the U.S. sees over 20 million civil lawsuits every year. About 1 in 5 end in a money judgment that leads to garnishment or levies. And that's why the wealthy don't play defense after the verdict. They build the wall before the first shot. But even if you're late to the party, even if you already lost, it's not hopeless. There's a legal structure designed precisely for this moment. Cliffhanger, because what happens next separates those who lose everything from those who keep living their lives untouched. Okay, let's talk about the offshore firewall and how it really works. After judgment, let's strip it down to the essentials. Step one, the Cook Islands Trust, the vault. When assets move into this trust, they leave the jurisdiction of U.S. judges. Under Cook Islands law, foreign judgments are void. To go after it, a creditor must start over in the South Pacific under a system that demands proof beyond a reasonable doubt and requires a hefty prepaid bond. Step two, the Cook Islands LLC, the lockbox. That LLC, owned by the trust, holds the offshore bank account. You're the manager, free to move funds, invest, and live your life. But when a threat appears, you step back. Step three, the licensed bonded trustee company law firm, the gatekeeper, our affiliate trustee firm, takes temporary control. So they're legally forbidden to obey U.S. court orders. Even if an American judge demands repatriation, Cook Islands law says, not our jurisdiction, not our problem. So think of it like autopilot on a jet. You fly it yourself in clear skies, but when turbulence hits, the system locks in and flies you through safely. Real world example. One of our long-term clients, a business owner with multiple properties, faced an unexpected multi-million-dollar judgment. His U.S. accounts were frozen within days, but the offshore structure held firm. Why? Because the Cook Islands trustee, governed by their own local laws, isn't subject to U.S. court orders. The funds remained safely out of the reach of the U.S. courts until the matter was resolved. And ultimately, the other side accepted a smaller settlement rather than spending years chasing a ghost. Moral: a well-built structure doesn't panic when the pressure rises. It simply follows the law of the jurisdiction it was created in. So that's how the right legal architecture gives you calm in the chaos. So think of it like a good estate planning. If you do it right, your heirs sleep well, and so do you. Okay, let's talk about offshore banking, where the money sleeps. Banking jurisdictions that don't cave. So let's talk banks. Offshore protection fails if your bank folds at the first phone call. In fact, I rate banking jurisdictions using a 5-factor safety test. Sovereign independence, will they ignore U.S. civil judgments? Political stability, will they freeze accounts in a panic? Bank capitalization, can they survive a crisis? Privacy statutes, is authorized disclosure a crime? Extradition pressure, will they cave to foreign demands? So now, based on those criterion, here's where serious money sleeps soundly. First of all, Switzerland, the veteran fortress. Article 47 of its Banking Act makes disclosure a felony. High Tier 1 capital ratios. It cooperates with tax law, yes, but it laughs at civil subpoenas. Liechtenstein, a micronation of quiet billionaires, no enforcement of U.S. civil judgments, and the royal family-owned LGT Bank specializes in trust funds. Next, Singapore, Asia's vault, common law system, heavy cybersecurity, and private banking assets exceeding $2 trillion. The challenge with Singapore, however, is it's really hard to open a bank account unless you live there. So we'll take that one off the list for now. Next is Belize, the comeback kid. After legal reforms, Belize now rivals the Cook Islands for trust protection, zero recognition of foreign judgments, and a 2-year statute on fraudulent transfer claims in the Cook Islands is now zero in Belize. Now, Cook Islands also has an excellent offshore bank that I use personally as well. Okay, now a little cliffhanger, but not every postcard country is our friend. Some of the safe places collapse the second a U.S. judgment picks up the phone. And I'll show you which ones in a moment. Okay, now the paper tigers, where rich people lose their shirts. First of all, the United Kingdom. Under the Hague Choice of Court Convention, British banks enforce U.S. civil judgment almost automatically. London looks classy, but it's a legal glass house. Australia, its Foreign Judgment Act makes enforcement fast track. Once registered, your account can be frozen within days. Canada, friendly neighbor, unfriendly laws. Courts enforce U.S. judgments under comity, that's C-O-M-I-T-Y. In Marsh versus Canada Life, 2020, an Arizona creditor seized a $4.2 million brokerage account in 14 days. Lesson, if a nation shares your Netflix library, it probably shares your court system. Okay, now the secret switch, control versus ownership. This is where most people blow it. They build the structure and then they keep the keys. Rule, you control it, the judge can control you. A Cook Islands Trust works because legal control sits offshore when trouble strikes, even when you keep beneficial interest. When there's no legal control, there's nothing a U.S. judge can order you to do. By the way, I'll just insert this here. One question that I get at this point is, well, can I trust the trustees? It's a licensed bonded trustee company law firm in the most regulated trust jurisdiction in the world. And being the person who set up more trust there than anybody in the world, I can confidently say it's a very trustworthy jurisdiction. In 30 years we've been setting up trust there, I've never seen anything but absolute impeccable integrity. Here's a real example. A California investor had $9 million in real estate equity. After a construction dispute, the court entered a $3.1 million judgment. His domestic LLCs were frozen, but his offshore LLC inside the trust, not reachable. The trustee refused to transfer. We had recorded equity stripping liens on all the properties, and the creditor eventually settled for the insurance payout, not a penny more. That's not luck, that's structure. And here's the kicker. When the dust settles, control flips back. The trustee steps aside, you resume management, and life goes on. Okay, here's another cliffhanger for you. But what if the judge says, bring it back or go to jail? Let's talk about the nuclear option, contempt orders. So we'll call this section the contempt dilemma and why it usually backfires. Judges hate losing control. So when assets are offshore, they'll often issue a repatriation order. Bring it back within 72 hours. If you can, you must. If you can't, you invoke impossibility of performance. Under U.S. law, you can't be held in contempt for failing to do something that's legally impossible. When a foreign trustee company law firm controls the account temporarily and local law forbids compliance, that's exactly the defense when these structures are properly built. U.S. courts simply have no legal authority over the trustee or the funds held offshore. So instead of conflict, what usually happens is clarity. The offshore trustee follows the law of his own jurisdiction, not foreign pressure. We've seen this time and time again. A client receives a court order demanding assets that are legally speaking outside of the court's reach. The offshore trustee law firm politely responds that the order has no effect under local law, and that's where the story ends. Outcome? The client keeps peace of mind and the assets remain protected. I once joked with a creditor's attorney who said, well, just work through international diplomacy. I told him, sure, good luck getting a Pacific Island parliament on the phone by Friday. Okay, now the banking layer, choosing the right offshore partner. Choosing an offshore bank is like choosing a parachute. Reliability matters more than color. Here's what we use for our clients. For example, a Cook Islands Trust plus a Swiss bank account, or even a Liechtenstein bank account, doubles sovereignty and alpine stability. Belize Trust plus Swiss bank account. Central American European firewall with zero judgment recognition. A Nevis Trust plus Swiss custody account. Strong for investment portfolios. Every account is transparent to the IRS. Full FATCA compliance. We protect from lawsuits, not from taxes. Offshore does not equal off the books. Okay, now the aftershock test, what happens when they try again? Here's what creditors usually do after losing round one. They file again under a new theory, threatening to subpoena foreign banks, try to freeze domestic income. It rarely works. Why? Because the Cook Islands trustee can't legally cooperate. They'd violate their own laws, and that's a serious offense there. In fact, I once saw a Florida doctor's lawyer demand his Cook Islands trustee transfer $2 million. The reply letter was one line. We regret we cannot comply. Your judgment has no force in this jurisdiction. End of story. Okay, cliffhanger to close. But what if Congress tries to outlaw this kind of protection? We'll address that next week and why no U.S. law can cancel a foreign nation's sovereignty. Okay, here's your action plan, how to build your own offshore firewall. First of all, visit assetprotectionplanners.com. You'll see a whole lot of free information there. And if you're serious, not just curious, and you have over $500,000 to protect, fill out the consultation form and schedule a confidential consultation with one of our professionals. Next, customize the trust. Real estate, crypto, brokerage, we tailor each clause. Form the LLC, acts as your offshore operating arm. That's what holds the bank account, and that's what goes inside the trust. Open the bank account. We give you options. You choose the jurisdiction that matches your risk profile. Fund and maintain. Clean audit trail, annual review, and a lawsuit fire drill once a year. Average full setup, trust plus LLC plus banking runs about what a single legal retainer costs in a big lawsuit. Perspective, pay once to prevent disaster or forever to defend against one. If you ever built real wealth, business, real estate, or investments, the lawsuit train is always running. You can't stop it, but you can make sure it never reaches your station. Offshore banking isn't about secrecy. It's about control through jurisdiction. So whether you've already been sued or you just want to sleep like the billionaires do, now's the time to act. Visit assetprotectionplanners.com or call 1-954-400-1050. Let my team, the same one that set up more Cook Islands Trust than any firm on earth, design your personal fortress before somebody builds a case against you. I'm Kevin, the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. Until next time, stay smart, stay protected, and keep your money yours.